Great. Thank you very much, Marty, for the introduction. Good morning, everyone. My name is Nicholas Reinkeluers. I am going to be presenting on the Working for Workers Act, or Bill 27, with a particular focus on the new changes to non-competition clauses and the right to disconnect. And with regards to the question you just mentioned, Marty, that is something that I'm going to be discussing in this presentation. So I'll just mention it when I get to that point. And if there is any further questions afterwards, we'll be available either in the Q&A session, or if you want to send a Q&A or message in the chat, I can respond that way as well. So to start with a brief overview of the Act, the Working for Workers Act was announced that it had been passed by the Ontario Legislature on November 30, 2021, and it received royal assent and came into effect on December 2nd, 2021. This bill includes many employee changes to employment legislation, including, among other things, a ban on non-compete agreements with only certain limited exceptions, requiring employers with 25 or more employees to implement a disconnect from work policy, establishing a licensing regime for recruiters and temporary help agencies, prohibiting certain regulated professions from including a Canadian experience requirement as a qualification, requiring businesses to allow washroom access for delivery workers, and implementing certain employment protections for foreign nationals. So to start with the timeline for when these changes come into effect, the majority of the changes came into effect upon the bill receiving royal assent on December 2nd, 2021. So in other words, they're in effect right now and have been for slightly over 2 months, but some of them have slightly different timing. In particular, the ban on non-compete clauses actually applies retroactively back to October 25, 2021. The disconnect from work policy requirement, employers have up until June 2nd of 2022, or of this year, to become compliant with this requirement. And the licensing regime for recruiters and temporary help agencies is coming into force on a date to be proclaimed, because the government hasn't established the licensing framework for it yet. So it's unknown currently when that's going to come into effect, but presumably will be at some point in the reasonably near future. So to start with disconnecting from work policies, subject to the Employment Standards Act, which has now been amended by Bill 27, employers with 25 or more employees will be required to develop a written policy for disconnecting from work. And the term disconnecting from work is defined in the Act to mean not engaging in work-related communications like emails or calls, and not sending or reviewing messages. The general idea of it is that employees should be free from performance of work outside of normal working hours, and it's required that the policy must include the date it was prepared and when any changes were made to it, if any. As part of these new requirements, an employer must provide a copy of their written policy to each of its employees within 30 days of the policy being prepared, and if the policy is amended, the amended policy must be provided to all workers within 30 days, and when a new employee is hired, the employee has to be provided with a written disconnect from work policy within 30 days. Employers are also required to retain a copy of every written disconnect from work policy for 3 years after the policy ceased to be in effect. And as I mentioned, the employers have 6 months from when the Act came into effect. So in other words, up until June 2nd, 2022, to implement such a policy. And if they haven't implemented it by then, they will be in breach of the Act and potentially subject to financial penalties. Now, an important point to make regarding the disconnect from work policy requirements is, apart from saying that it must include the date it was prepared and when changes are made to it, the Act doesn't actually mandate any specific contents on what the policy must contain. The bill does provide that the written disconnect from work policy, quote, shall contain such information as may be prescribed, end quote, which essentially what that means is the government is leaving it open for a regulation to be passed in the future mandating specific substantive content as to what the disconnect from work policy could contain. I mean, you can imagine the government might pass rules on, what would be a reasonable policy if there's exceptions to the policy when employees still have to work outside regular working hours and answer emails. Well, what's reasonable and not reasonable in terms of exceptions. However, currently no such regulations have been passed. So this will be something to watch to see what happens in the future, because currently, in my view, the new disconnect from work policy requirement, it doesn't really have a huge amount of teeth, in the sense that, again, it hasn't been interpreted by the courts yet because it hasn't yet come into force, but it appears that employers must have a policy, but the court or the government hasn't actually passed anything specifically saying what the substantive content of the policy needs to be. But again, that's been left open by the Act for future regulations on that to be passed in the future. So that's something to keep an eye on. And we potentially may be having future presentations on that, depending on how the law on this develops. So to move on to the second major issue I'm going to be talking about in my presentation is Bill 27 now bans non-competition agreements in most employment contracts. And a non-competition agreement is defined in the Act as an agreement or part of an agreement between an employer and an employee that prohibits the employee from engaging in any business, work, occupation, profession, project, or other activity that is in competition with the employer's business after the employment relationship between the employee and the employer ends. And to get into a bit more detail on that, non-competition clauses are something that many employers quite commonly throw in as a standard term in their employment contracts, often without really considering whether the clause is actually really necessary or enforceable, or if it came down to it, whether they would really actually likely seek to enforce it. And typically the kind of wording you'll see in one of these clauses is it'll provide that when an employee stops working with the employer, whether it's because they resigned or been terminated or for any other reason, there'll be a certain set period of time, it could be 3 months, 6 months, a year, 2 years, when the employee won't be permitted to work for a competitor, and the clause will hopefully define what is meant by a competitor within a specific geographic radius. So it could say 5 kilometers, 10 kilometers within the GTA, within all of Ontario. Now, a lot of employers like to put these clauses in their employment contracts, again, sometimes without really thinking about it too much, but the courts are quite, even before Bill 27 at common law, which is judge-made law, the courts have been very strict in enforcing these clauses, and most non-competes, I would say, even before Bill 27, are probably unenforceable, and the court would really only enforce them when they were really strictly necessary to protect a legitimate business interest of the employer and were clearly defined, reasonable in scope, and had a reasonable timing and geographic constraint. And essentially, if you were an employer, it is and continues to be important to have the clause drafted clearly, concisely, and as narrowly as possible, so that it's only limits the employee's competition to the extent reasonably required to protect the employer's interests. And so, just to give a simple example of a clause that would likely be found unenforceable at common law, if you have a senior employee working for your business strictly provides services in the GTA. If you have a clause that prohibits the employer or the employee from going to a competitor anywhere in Ontario, that clause is probably going to be unenforceable, because it would, in theory, prevent the employee from, say, going to a competing business in Ottawa, even though if you only do work in the GTA and the competitor only does work in Ottawa, you're not really actually competitors. There's no actual real legitimate reason. So that clause would likely be struck down as enforceable. And there's lots of different reasons clauses are struck down. It could be that the employer has said it needs to be in place for 2 years, and the court only thinks it's necessary for 1 year, or they just don't think it's necessary at all, given the nature of what the employee actually did. But that's just an example of the types of things the courts look at. So the big change with Bill 27 is that the common law continues to apply. However, in addition to the common law, certain, or essentially all, non-compete agreements in employment contracts are now unambiguously expressly prohibited, except in 2 limited exceptions. And so the first exception is when the clause relates to the sale or lease of a business. So when a small business is sold, it can be quite common for the seller or proprietor of the business to stay on as an employee to assist the purchaser with a smooth transition of the business and customer base from the seller to the purchaser. And in those contexts, Bill 27 does not prohibit a non-competition clause, and the policy rationale for that is that if someone's buying a business, they have a reasonable expectation that the person selling it is not going to, turn around and 6 months later opening up a competing business, just down the block, because part of what you're buying, most presumably, is the goodwill and customer base of the business. The second major exception is in Bill 27 is that it does not prohibit non-compete agreements between an employer and the employer's executives. And executive is specifically defined in Bill 27, and I've put the definition in the slide. It's essentially someone who has to be, you need to be quite senior, a C-suite executive, like for example, the CEO, CFO, and so on. Whether someone is considered to be an executive is, we anticipate, probably something that's going to be a focal point of future disputes as to whether non-compete agreements are enforceable. And just to emphasize again, that even if your non-compete agreement falls within these exceptions, meaning it relates to the sale of a business, or it is within executive, it doesn't, just because it doesn't fall afoul of Bill 27, it's not automatically enforceable. It still has to comply with the common law, meaning that it's not overly broad, it's clear, and it's necessary to protect a reasonable business interest of the employer. So if you are trying to rely on a non-compete clause in agreement, it's important to seek legal advice to make sure the clause is properly drafted and it's likely to be enforceable. In terms of the timing and application of these new these amended rules regarding non-competition clauses, these amendments to the ESA are deemed to be enforced retroactively up to or back to October 25, 2021. And there's been a couple of recent cases that appear to confirm that this is how the law is going to be applied, meaning that, in other words, if you have a pre-existing non-compete agreement that was entered into prior to October 25, 2021, that clause is not going to be impacted by Bill 27. So it may, it's not going to be automatically unenforceable, although it may, could or could not be enforceable under the common law. So if that clause is important to you, it's probably wise to consult a lawyer to have advice on it. But any clauses or any employment agreements entered into on or after October 25, 2021, they contain a non-compete agreement that doesn't comply with Bill 27 will be barred and unenforceable. And it's important to note that in addition to the clause being unenforceable, there's also a financial penalty for not complying with the act, and employers can potentially suffer penalties. So that covers that. I've now covered the two main topics I wanted to talk about: disconnect from work and the non-compete agreement ban in Bill 27, which I think are really, for most people, the major changes in the act. They'll be introduced by Bill 27, but to talk briefly about a few other changes that have been implemented by Bill 27. One of them is it started the process of introducing a licensing requirement for temporary help agencies and recruiters. Essentially, it's going to require all recruiters and temporary help agencies to be licensed. It's going to be yearly license that will be non-transferable, and there's going to be a public database that lists all active, revoked, and suspended licensees. And an employer is going to be prohibited from using the services of any recruiter or help agency that isn't licensed. So this hasn't come into effect yet because the government hasn't yet set up the framework for implementing these licenses. But presumably that's going to happen at some point in the reasonably near future. So if this applies to your business, it's something definitely to keep an eye out on. To briefly talk about some of the other changes, the Bill 27 is trying to lift barriers for internationally trained professionals by removing certain Canadian experience requirements and duplicate official language proficiency testing. It's also, another notable change is it's providing for a right for washroom access for couriers, truck drivers, and other delivery workers who generally will have to be provided with access to washrooms anywhere they're picking up or delivering things, with certain limited exceptions to where it wouldn't be practical or reasonable for health, safety, or other reasons. Final change, just briefly mentioned, I put it up on the slide. There's going to be new prohibition on recruiters taking fees from foreign nationals when they're reaching out to them. And the goal is to try to protect foreign workers and avoiding scams and deceitful recruiters when they're looking for work in Ontario. So I'm almost out of time. So just to do a brief overview and summary of the major changes we just talked about and what we suggest employers do is any employment agreement that's been entered into on or after October 25, 2021, you should look at it and make sure it does not contain a prohibited non-competition clause, because if it does, and one, it's not enforceable, and two, there could be a financial penalty. Something you might want to consider if you realize your employment contract does have one, is send a letter to the employee advising that you don't intend to enforce the clause. If it's required, you may want to consider alternative types of restrictive covenants. So for example, the Act doesn't expressly prohibit non-solicitation clauses. So in other words, preventing an employee from expressly soliciting the customers of your business as opposed to competing as a whole, that may still be enforceable. It's not strictly barred by Bill 27. If you want to rely on the executive exemption under Bill 27, you want to make sure those job titles are clearly defined. And if you have 25 or more employees, an employer must prepare a disconnect from work policy, and employers who use recruiters and temporary help agencies should follow the law on that as it develops. And once the licensing requirements come into effect, to make sure that any recruiter or temporary help agency that they use is properly licensed by the government. So that is the end of my presentation. So thank you very much for listening. I will be around for the Q&A later, and I can also answer any questions that are submitted via the Q&A feature. And I'm going to pass it on to Marty, who has our final presentation of the day.